In September 2020, Senator Kristina Keneally, Shadow Minister for Home Affairs and Shadow Minister for Immigration and Citizenship, delivered a speech to the Australian Strategic Policy Institute claiming that Australia is the only member of the Five Eyes network not to proscribe a white supremacist group as a terrorist organisation. This short video is designed to explain what this means. Since her speech in September 2020, some media organisations have tried to provide commentary about the debate, most notably Guardian Australia. However, the commentary provided has not been terribly good, encouraging the intuition that if you're against white supremacy, you'd be in favour of proscribing a white supremacist group. Worse, the prevailing rhetoric is that these counterterrorism powers should be done as a symbolic gesture just to show how much we disapprove of white supremacy. So what are we even talking about? Most people think they know what they mean when they talk about terrorism. They usually mean a type of really, really bad crime. Deep in their gut, people think they know terrorism when they see it. But this gut instinct is often racialized, and it can lead to a lot of contradictory intuitions based on political ideology. In Australia, we have a legislated definition of terrorism. Section 100.1 of the Criminal Code defines terrorism in an unhelpfully legalistic and convoluted way, which I'm going to try to simplify. Think really bad, life-threatening crime or the equivalent level of seriousness for electronic systems. But don't include acts that are advocacy, protest, dissent, or industrial action where it wasn't intended to harm anybody or create a serious safety risk. If you've met this seriousness threshold, then it will be a terrorist act only if that act was done with the intention of advancing a political, religious, or ideological cause by coercing or intimidating the government or broader population. Perhaps this is oversimplified, but you get the gist. The United States, on the other hand, has a different definition of terrorism. Here is their definition of domestic terrorism. Again, we're talking serious levels of crime, but only those which are dangerous to human life. And then we slide quite quickly to the intention behind the dangerous criminal act. But we need to be really sharp and careful about what we're talking about here, because these two definitions aren't really comparable. The bit that people miss is that it is an offence in Australia to commit a terrorist act. But the US definition does not point to an offence. Instead, if you engage in domestic terrorism, you are charged with the underlying criminal offence needed for the threshold test. There is no prohibition on being a member of a domestic terrorism group. Indeed, you can, in the United States, lawfully be a member of a terrorist organisation. You can walk into the Supreme Court of the United States, declare that you are the leader of a domestic terrorism organisation, and the Supreme Court will still stop laws that prevent you from making a speech arguing that whites should take, quote-unquote, revengeance against African Americans and Jewish Americans. By now, we should see that there is a problem with the rhetoric being used in the proscribed terrorist organisations discussion. There is no consistent definition of a terrorist organisation across the Five Eyes countries because there's no consistent definition of a terrorist. And the significance of being a proscribed organisation is different between countries. So how do you compare each country's list? In Australia, it is an offence to be a member of a terrorist organisation, A terrorist organization is an organization that is directly or indirectly engaged in blah, 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 a terrorist act. Or it's an organization that is specified by the regulations. It's this second bit that we know as proscribing a terrorist organization. So there's two ways for you to be convicted of an offence for being a member of an organisation. Either the minister has declared the organisation to be a terrorist organisation, or a court has heard evidence that the organisation was a terrorist organisation and forms the view that the organisation meets the description. If you are intellectually serious, you have to engage with the question of how comfortable you are with this process. One pathway affords a person accused of a serious crime to lead evidence that the organisation is not actually a terrorist organisation, but the other does not. It should sit with you in your belly and make you squirm a bit. There are clearly going to be organisations where it is simply beyond doubt that they are terrorist organisations, and it is unnecessary for a court to entertain the possibility that they are not terrorist organisations. But that is going to be a very limited number of cases. For a minister to blanket ban an organisation, you want these to be the worst of the worst cases. Australia has listed 27 organisations, all of whom are linked to Islamic extremism. And although we have proscribed 27 organisations, they are not all independent organisations. But there's some debate about how systemic the government is, about which organisations to include and which to exclude. There are a few analysts who point to the fact that it's strange that one organisation is listed while an objectively worse one is not, etc., etc. And there's some debate about whether or not organisations should be listed at all. Serious people make the very reasonable argument that if the government wants to ping people for these crimes, it should put all the evidence on the table that the organisation is a terrorist organisation. This is linked to ideas about procedural fairness and justice, and about limiting the powers of the government. So we're most of the way there. We know what we mean when we say proscribe, and we know that there's a debate about whether or not this is appropriate. We know what we mean when we say terrorist organisation, and that different organisations will meet different definitions in different countries. We also know that Australia uses a two-prong model. The list of terrorist organisations is not an exhaustive list, as courts can also be presented with information stating that the organisation is a terrorist organisation. But what do we mean by white supremacist group? First, a note on terminology. It is extremely popular to use odd euphemisms for white supremacist groups. We should, to the greatest extent possible, make it clear that we are talking about white supremacist ideologies. They promote and glorify violence towards minorities in a way that we have, historically, been able to identify and combat. Terms like alt-right are propaganda terms used by these groups to suggest that they are not white supremacist groups. And the term right-wing extremism is both ambiguous and has the incorrect implication that other organisations listed are left-wing. The UK, which has a fairly different legal framework to ours, mostly prescribes Islamist groups, but they've also listed some separatist groups. The white supremacist groups that they've listed are the unambiguously awful ones that have engaged in activities that most reasonable people think, yep, there is definitely no way that this group is lawful. Canada, which has a legal framework that is quite similar to Australia's, largely has a similar list to that of the UK. New Zealand has something a bit strange. And that's the listing of an individual person. Following the Christchurch massacre, the person responsible for that violence was listed as a terrorist entity. It is kind of awkward. So it's definitely possible to proscribe a white supremacist group. We know that some of the groups proscribed by the UK and Canada operate here, for example. But should we? Bad reasons to proscribe these groups include the fact that other countries have done it and we risk looking like the odd one out. It's similarly a bad reason that it's a symbolic gesture. Remember, we are dealing with one of the heftiest clubs of the executive power that we've got, where everybody else gets to argue before the courts that they're not involved in terrorism. This pathway severely curtails those rights based on intelligence that courts will never see. This is not a shits and giggles power. On the other hand, we might want to proscribe some of these groups if we have concerns that the more violent groups are mobilizing and we would like to restrict their resources. We might also have concerns that they are mobilising overseas and do not want Australians funding atrocities abroad. Finally, we might have concerns that, because of the way some of these groups operate, it would be extremely difficult, if not impractical, to secure a conviction. By prescribing the worst of the worst, you don't need public evidence to secure that conviction. And that's the end of this one. Regardless of which way you sit on this question, you deserve to have a well-informed and rational debate about it. If you do not have the necessary information, you can't get involved in the political process. Follow me on Twitter @LegalReckoning, and I will see you next time.